Good evening, everyone. My name is Ravi Naik. I'm the legal director of AWO, so law firm specialising in digital rights and technology. I'm also an honorary professor of practice at UCL. And thank you all for joining us today. I'm sure many of you have only recently returned to your desks, so we're very grateful to you for taking the time to be with us here this evening. And we're putting on an event so early in the year gives us a chance to reflect on the year that's just gone. And anyone with more than a passing interest in AI and automation could be forgiven for thinking that AI was gifted down by Silicon Valley tycoons in 2023 alone. Yet AI, and more broadly automation, has been discussed for decades. And concerns about the rise of automation and digital technology have traced and shadowed those developments. Some of that concern has been misplaced, but others have proven quite salient and required legislative intervention. And while automation has been with us for a while, so has a suite of relevant laws. Indeed, since our inception in January 2020, my colleagues at AWO have been involved in the development of a range of new regulations concerning digital technology in the UK, EU and beyond, including the Online Safety Act, Digital Services Act, the DMA, and lastly the AI Act. These laws build on other norms, such as the General Data Protection Regulation. So certainly our discussion today occurs in a far from lawless landscape. So is anything so different in the year ahead? Almost daily there seems to be a story about new risks from new technology that may come. That while rudimentary technology could be regulated, it will be much harder to remedy the injustices that will inevitably follow their deployment of AI. But for every reported potential of 40% of workforces being replaced by AIs, workers have been fighting for years for their rights over technological shifts to their jobs. And for every discussion about hypothetical existential crisis that may arise from AI, individuals have had and are having decisions about their liberty and life-saving medical treatment decided solely, or at least in part, by automated means. Simply, despite the suite of laws available, harms do arise from technology and automation. And this year will see courts dealing with claims concerning the impact of technology on individuals. Indeed, 2024 will see a series of cases over which AWO has conduct decided. And the central theme running through those cases is the real and human impact of automation. From individuals seeking agency over invasive profiling and targeted data processing, to exploit vulnerabilities, to automation bias, to facial recognition technology, to public sector use of technology, through to the use of data in the electoral process. 2024 will see a marked shift in scrutiny of technology by the courts and regulators. But despite that flurry of judicial and regulatory action, the government is considering and consulting on new laws. Yet the role of courts, regulators and lawyers is often a second-order question. And in that context, and in the backdrop of national and international AI summits, AWO will be putting on a series of events throughout 2024 looking at the reality of enforcing the law against technology to understand how the courts, lawyers and regulators will consider issues. And I'm really thrilled to be able to commence these events with UCL and Brick Court Chambers for today's topic, automation, AI and justice, views from the court. Joining me today on a panel discussion will be Sarah O'Keefe, a barrister at Brick Court Chambers, practicing in competition, commercial and public law, and with a rare background of experience in private international law and AI. And Sian McGibbon, who's a public law barrister at Landmark Chambers, and also a PhD researcher at UCL, looking at legal accountability and oversight of public bodies in response to issues raised by digital governance. And our audience. There'll be plenty of time for question and answers at the end. But first, I'm very delighted to introduce our keynote speaker for this evening, Sir Richard Aikens. Over to you, Sir Richard. Thank you.
Good evening, ladies and gentlemen. I've called this talk tonight, Artificial Intelligence, on what basis should AI be liable for damages caused by errors or omissions? Artificial intelligence already affects our everyday lives. For example, it's used in radiology for analyzing mass screenings for breast cancer. It can summarize information and make decisions, for example, on which people should be shortlisted for a job. or to whom to grant a loan and on what basis. It's involved in the actual manufacture of goods and allied activities, such as predicting markets or requirements for materials or components. AI can invent products and processes. AI, of course, produces material for the World Wide Web. AI's even more widespread use in our lives is just around the corner. We're told that driverless vehicles will be on our streets in 2 years' time. Autonomous cargo ships are already in trials, particularly in Norway. By 2035, perhaps 35 to 40% of the world's cargo fleet could consist of autonomous vessels. Some military equipment is already autonomous, and it will be increasingly so. It might even solve the Royal Navy's recruitment problem. But what if, as a result of something done by AI, something goes wrong? A person is physically harmed, or there's a financial consequence for a company or an individual of a decision based upon AI analysis, or a product is defective, for example, because of a defective design produced by AI, or how are intellectual property rights created by AI to be protected by a patent or a trademark? Can English law deal with these matters now? And if not, what should be done? That's what I want to speak about briefly this evening. Take the case of the driverless car. It crosses a red light, crashes into another car, which is driven by a man, correctly crossing on a green light. That driver, who is a successful businessman, we imagine, is killed. But the person in the driverless car, its owner, escapes virtually unharmed. The family and the estate of the driver killed wish to sue for damages, and the police wonder whether any crime has been committed. Ordinarily, this would probably be a case of causing death by dangerous driving. But a machine cannot commit a crime under current legislation. Only, when a machine is involved, the person, legal or human, that is legally responsible for the work of the machine. The owner of the driverless car has not committed the crime of causing death by dangerous driving. The owner of the driverless car was not at fault because he was not driving and he was not responsible for the car going through the red light. So on what basis could the family and the estate sue him in the absence of fault? Or take the case of the autonomous vessel carrying a cargo of containers. She is on a voyage from the Far East to Rotterdam. She sails through the English Channel, the busiest waterway in the world. Something goes wrong. The ship veers out of the northbound shipping lane, they're clearly defined in the English Channel, and collides with a southbound chemical carrier. Both ships sink. The container cargo is lost, and the lost chemical cargo causes considerable environmental damage on the English and the French coasts. If the autonomous ship had been manned, then that ship would be liable for damage caused by the collision if faulty navigation or management of the ship were proved. What is the basis of liability if the ship is unmanned and not even controlled from the shore, but is entirely autonomous? These examples can be multiplied to cover various other situations where, as a result of activities by AI, damage is caused to a person or a company. At the moment, English law has no clear answer to the question, how do you make someone liable in a civil claim for the act or omission of AI that results in damage? The government produced a white paper in March of last year, 2023, updated in August 2023. It was entitled A Pro-Innovation Approach to AI Regulation. However, as the name of the paper indicates, it is concerned with regulation of AI, not with issues of liability for damage caused by the use of AI. The white paper has nothing to say on that topic other than to state that any new regulatory regime in relation to AI, which is intended to be, quotes, non-statutory, close quotes, would, quotes, not create new rights or new routes to redress at this stage. The UK is not alone in not having produced any comprehensive code on the question of civil liability for the acts or omissions of AI. The USA has no federal laws specifically on this topic. Even a state like California, you might say the home of AI, has not got much further than passing laws to regulate self-drive vehicles. There is no specific legislation in Canada or Australia. The EU has updated its directive on national laws relating to liability for defective products with the aim of having a common rule of strict liability. That focuses particularly on consumer products. There's also an AI Act of the EU, which deals with regulation of AI according to the risk level of the particular AI in use. But the proposed directive on, and I quote, adapting non-contractual civil liability rules to artificial intelligence that was produced by the European Commission in September 2022 doesn't seem to have got any further yet. The proposal itself is quite modest. It does not propose a change to the basis of non-contractual liability, in other words, fault. Instead, it aims to, and again I quote, ease the burden of proof for victims trying to prove their liability claims, depending upon the type of AI involved, whether high risk, medium, or low risk. There is a proposal that the liability regime of member states be reviewed, leading perhaps to a harmonization of a strict liability regime for AI use cases where the AI is a high-risk type of AI, but the draft directive on non-contractual liability has yet to be passed by the European Parliament or approved by the Council of Ministers. So what should the UK do to address this issue of liability for damages caused by the acts or omissions of AI? At least we have made a start. The result of a 4-year-long review and reports by the Law Commissions of England and Scotland was the Automated and Electric Vehicles Act of 2018. It introduced a definition of self-driving vehicles in law. It contemplates that there will be a user in charge of the automated vehicle. The user in charge will not be responsible for the way the vehicle drives when it's in self-drive mode, but the user in charge will remain responsible for insurance, the security of loads carried, roadworthiness of the vehicle, and non-driving offences such as illegal parking. On the issue of civil liability, the Automated and Electronic Vehicles Act 2018 introduced new legislative provisions to smooth the path to compensation for those injured by AVs. Thus, each AV, that's to say automated vehicle, must carry insurance that binds the insurer to pay compensation for any damage caused by a vehicle whilst it's driving itself. This effectively means that a system of no-fault liability is introduced by means of insurance. But what happens if, as is so often the case with manned vehicles, there is no insurance? Will the Motor Insurers Bureau have to take up the burden? It would be costly. So this doesn't totally solve the liability problem of the driverless car going over the red lights and another car being hit and the driver killed. In January 2022, the English and Scottish Law Commissions produced a further joint report on automated vehicles. It deals with standards for production, testing, maintenance, and also with criminal and civil liability. In essence, the Law Commissions propose that there be new offences that can be committed by companies that produce or maintain AVs if that results in an accident, but that if a criminal offence is committed when the vehicle is driving itself, the person in the vehicle or its owner should not be capable of being charged with a criminal offence. Apart from this area, there appear to be no legislative plans on the stocks to deal with the issue of the liability gap. How might it be dealt with? A preliminary question might be, should any item of AI have a legal personality so that it could be the subject of a legal claim? This seems to me to be a basic issue. My answer to the question would be yes. AI does what otherwise would be done either by or under the direction of a human who is usually legally responsible for what is done or is not done. Others, in a superior position to that human, may have to take legal responsibility for that human's error or omission. But it seems logical to me to put AI in the same legal position as a human who does things or fails to do them. This would therefore require all items of AI that engage in work that involves others in some way to have a legal identity. Ideally, this would be dealt with by an international convention, but that might take years. In the meantime, I suggest it should become a national requirement. Secondly, what about liability under contract? Can AI enter into a contract with another person, legal, human, or indeed perhaps AI? If you give AI legal personality, then in theory, I think it could. It could therefore enter into contractual obligations and liabilities. Either it would do so on its own behalf or on behalf of a human or other legal person. At the moment, it's difficult to envisage AI acting as a principal in concluding a contract, but this might evolve. Should there be legislation that states that if AI enters into a contract with another, which is obviously possible on current technology, then it must do so as agent for another legal or human person who is to be responsible for the contractual obligations of the AI party to the contract. If not, then there is the possibility of AI entering into a contract, not being able to fulfill it, and the other side suffering damage as a result, and the AI cannot pay those damages. Perhaps there needs to be a compulsory liability insurance scheme to deal with the possible liability where AI has entered into a contract and then is in breach. That is not generally a legal or other person or humans who enter into contract, save in some areas where liability insurance, that is not the case where a legal or other legal person or human who has entered into contract has to have insurance, save in some areas where liability insurance is compulsory or a professional requirement. But in cases where insurance is not required, at least the counterparty is able, if a commercial party, to judge the creditworthiness and commercial reliability of the other party to the contract. In the case of AI as a contracting party, it's obvious that the AI entity has no financial means and creditworthiness is nil in that sense. Perhaps in the not too distant future, AI will be able to have assets and to be party to insurance contracts itself, but that will produce more challenges. If AI is responsible for some error, then the entity that owns the AI may be legally responsible to a human person or legal person that suffers damage. I will come on to the possible legal basis for that in a moment. But if someone successfully sued the owner of the AI, would that owner have any redress against the manufacturer or seller of the AI? If there's a contract, then assuming commercial terms, no Unfair Contract Terms Act regime applying, how would a claimant prove that there was a breach? And on what terms? One can imagine that it would be very difficult to prove any breach. And there's going to be the problem of possible reverse engineering by the AI so that any error in algorithms or other processes are eliminated by the time investigation is done. AI is, or soon will be, capable of covering its tracks. should the idea that has been adapted in the draft EU directive that there be a presumption of the relevant AI not being fit for purpose for which it was sold, taking the words from the Sale of Goods Act, be used if damage was caused? There might also have to be a change in the law on how causation is proved. Would there have to be a presumption that there was a causative link between the damage and the functioning or non-functioning of the AI? That is something that is dealt with in the draft EU directive. How then about the liability of AI towards the person who suffered damage as a result of the acts or omissions of the AI itself? The obvious basis for this liability would be either in contract or tort. Imagine AI is used by an investment advisor to advise on investments, and as a result, investments are made which are disastrous, and that's not because the market hasn't fallen, but because the AI has not properly analyzed the relevant company results, etc., because of something in the algorithms or the other setup of the AI. Is the company that employs the AI liable for that error? How is it to be proved? How is the relevant evidence produced? It's going to be an expensive and time-consuming business to investigate. Again, I think there's a case for legislation on issues of proof of causation and ability to interrogate the AI for evidence, at the least. What about non-contractual liability? Take the case of AI being used to analyze mammography results. At present, all are checked by human radiologists, I understand, but the proposal is that this becomes entirely an AI process, which would speed it up very considerably. What if there's an error in the AI system and randomly a person who should be warned of breast cancer is given a green light and treatment is delayed with devastating results? Is the hospital that used the AI automatically liable to the patient who suffers? On what basis? Is there a case for introducing a strict liability rule in tort where the damage results from the use of AI? If so, then a new rule on a presumption of causation would also have to follow, or else there would be complex factual issues to be dealt with. To my mind, this also raises the need for compulsory liability insurance in relation to the use of AI. This will probably mean the insurance company using AI to assess the risks attached to the hospital using AI as a diagnostic tool. So it will go on and on, rolling like a large snowball. Taking the issue to the international field, if autonomous vessels are widely introduced, then although the hope is that this will much reduce or even abolish human error in navigation and management of ships, accidents and damages resulting from failures by AI cannot be eliminated. Will the current internationally accepted fault-based regime for collision liability remain acceptable? I doubt it, because of the difficulty of proving faults when the AI concerned is at the bottom of the sea. I suppose there could be a means of replicating the AI and all it does in a land-based server, in inverted commas, and perhaps that requirement will be one of the first issues for an international convention. Apart from collision liability, there's also liability for damages to cargo where a ship takes a wrong course and grounds, or cargo is damaged because of insufficiently ventilated, or the AI miscalculates the distribution of containers on deck, and some are lost in a storm. All these causes of loss and damage to cargo are currently dealt with, at least in 99% of cases, by a 1968 maritime convention called the Hague-Visby Rules, which of course have not been adapted yet to deal with autonomous vessels. Will they work in that brave new world? I have argued before that they can, but the problem will be with evidential proof of faults. Ultimately, the world will need new international conventions on both collision liability, liability for loss and damage to cargo in the case of autonomous vessels, and so forth. Such conventions take a long time to produce. We need to start now, and bearing in mind the disastrous history of one attempt to change the rules, the Rotterdam rules, they must be kept short and simple. And we're going to have to do the same for international carriage of goods by road, by automatic vehicles, and ultimately carriage by air in automated aircraft. Lastly, a word on the issue of AI and intellectual property. AI can invent both physical items and processes, but the UK Supreme Court has very recently held, in Thaler and the Comptroller General of Patents, Designs and Trademarks at the end of last year, that AI cannot register a patent. I presume it couldn't register a design or a trademark either. That's because of the way the legislation is worded. Should AI be able to register an invention or a design or a trademark, would the problem be solved simply by giving AI legal personality? This is an issue which I think needs addressing too. I've only skimmed the surface. There's a lot for the government and all interested parties to consider. The need is pressing. Those who improve and produce AI will not wait for governments to act on these things, and the longer the delay in dealing with them, the greater the liability gap. Although the present government is following other obsessions, I believe the legal liability issues raised by AI are urgent and of the first importance. The ministerial foreword to the white paper published last year stated that the aim was to make the UK, I quote, the best place in the world to build, test and use AI technology. Good regulation is not enough to ensure that. Issues of legal responsibility and the proper basis for legal liability resulting from the use of AI are equally important and equally urgent. My advice to this government and the next is get on with it. Thank you.
Thank you very much, Sir Richard. That was fascinating. Lots of brilliant ideas. And the idea of AI upending society as well as needing to upend the law, introduce new concepts to deal with it. Sarah, Sian, drawing on Sir Richard's keynote, particularly these ideas of legal personality and gaps in the law, what are your views on liability gaps and how they may be filled? Maybe Sarah first?
Sure. So I think legal personality is definitely one idea that's been spoken about in terms of how to fill the liability gap. There have also been other suggestions. I think when we talk about liability gaps, it's important to sort of understand in concrete terms what kinds of things we're thinking about here. So if we take, for example, an AI that's produced to turn a valve in a factory on or off, right? So let's say it's maybe responding to changes in temperature, and this AI has been produced by what we'll call an AI producer. It may then have a front-end operator who might be the person in the factory who's sort of looking after the AI on a day-to-day basis, switching it on or off as needs be, whatever. And then you might also have a back-end operator who might be in some way affiliated to the producer but might not be, and they might be responsible for making sure that the AI is getting all the updates that it needs. The kinds of situations where problems might arise might be, for example, if an update to the AI changes the code in such a way that it no longer does the job that it's supposed to, and that could have been unforeseeable, and then under tort law, the person responsible for sort of putting that update forward wouldn't be liable under tort because it was unforeseeable, right? In the same way that it wouldn't have been foreseeable to the front-end operator or to the producer that that sort of clash of different codes or clash of learning of the AI as it goes about its daily business and rewrites itself might have had consequences that weren't foreseen. So that's the kind of problem that we're facing here. And one solution is to sort of create a sort of legal personality for the AI itself. Another one that's been suggested is just to sort of treat this as a very complex example of product liability, right? Where we've also had these kinds of gaps in the past, but this is just a really complicated version of that. So one thing that people have suggested is to assign liability to the cheapest cost avoider in those kinds of scenarios, which will be different in different contexts. So it might be that the company who is responsible for specifying the design of the AI that they're going to use and is responsible for looking after the updates and making sure that everything is still ticking along, it might be that they happen to be the cheapest cost avoider in a particular scenario, and therefore maybe we should impose strict liability on them. In other contexts, such as the driverless car, it's been suggested that maybe the producer of the car, who's responsible for incorporating the AI into the vehicle, they might be the cheapest cost avoider in that kind of situation. So I think the liability gap is definitely a real issue, and probably one that will take sort of sector-specific legislation and consideration to address. Domestically, it should be hopefully just about manageable, albeit more complex than the kinds of things that we've seen in the past. But I mean, for example, the mesothelioma cases, that was a way to get around some of these difficulties of establishing and proving fault and of sort of disparate ways of attributing liability, and the common law was able to come up with that. So we'll have to think about it. I think where the real issue lies is when we're talking about essentially different attribution of liability in different countries and how we deal with conflict of laws scenarios in these kinds of cases, because it's clear that there's a range of reasonable right answers to this, right, in different situations. So it could be a front-end operator is designated as the sort of best person to be responsible in country A, but in country B, they might designate the producer, right? So if you have suffered harm as a result of an AI that has some bits managed, that has has been produced in a country where the designated sort of person responsible under Rome 2 would be the operator, but the person doing the operations is in a country that designates the producer, then you can see how an individual's claim might fall through the gaps where there are different international regimes in a way that they would have a valid claim if everyone was in one place, right? So I think civil liability gaps are definitely an issue, more manageable domestically, harder internationally.
That's great. Thanks, Sarah. Sian, do you
Yeah, I think there are absolutely some going to be gaps in liability that emerge, as Richard and Sarah have said. But I think there are also some gaps that are not gaps in terms of the substantive regimes that could apply per se, but we just haven't figured out how to apply the rules and regulations and principles that we already have, that are already well developed, to this new system. And I work in public law, and you kind of see that, where there are really well established principles that definitely could be applied to hold public bodies to account for decisions that they're making and functions that they're exercising, but they're now using algorithms as a tool for those functions. And these principles can be applied, but we kind of, not enough thought has been given to how to bring those kinds of claims, how they could be formulated and presented to judges in a way that is kind of makes legal sense and bridges the gap between the technology and the existing principles. A kind of classic example of that is a decision it's an Australian decision, but it illustrates it. It's by the tax courts called Pinterich, and the equivalent of the judicial review procedure held that a letter that had been automatically generated by the tax authority wasn't a decision, even though it looked identical to a letter that had been sent by a human for the purposes of that procedure. And that was not a gap in liability, because the procedure existed, all the principles to be applied existed. It was just a gap in terms of kind of the judicial literacy and understanding of what the automated system is actually doing, and being able to recognize it and then plug in these sets of these liability regimes that already exist and apply them properly. So there are going to be gaps in liability, but I think we're maybe not even at the stage in some areas where we're able to apply the principles that we do have. And once we can do that, then it will be more clear where the gaps actually are.
Thank you, Sian and Sarah. Phrase you use, Sian, of judicial literacy. It's very interesting. Just drawing on that, and maybe for you, Sir Richard, to start with. do you foresee a role for AI or automation to assist judges in, for example, damages assessments or criminal sentencing? And how should the courts, if that is implemented, guard against problems that may be caused by, for example, automation bias?
Well, let me give you a little bit of history. I remember going to a talk given by Lord Mustill. It must be 30 years ago, more, when he was still a judge at first instance. And he'd just been out on circuit, and he'd had to deal with a lot of personal injury cases, comparatively small claims. And he was talking about his experience. And then he said, the time will come when these cases are dealt with by a machine that's on the bench. And the advocates, I don't think he got quite as far in his thinking, although he was very advanced technologically. He hadn't quite got as advanced as thinking that it would all be done automatically in terms of submissions. But he envisaged the advocates addressing the machine on the issue of liability, and then addressing the machine on the issue of the quantum of damages. So it's, in that sense, not a new idea at all, the idea of machines helping the judiciary, machines being the judiciary. Would it actually work? In theory, if there was no problem with the facts, a machine must be capable of analyzing those facts and producing a result on liability. Humans get it wrong, and judges obviously get it wrong from time to time, so the fact that machines might get it wrong wouldn't be that different, I don't think. What about the assessment of damages? Again, there's an element of predictability about this in, for example, personal injury cases, so that a machine can be taught how to deal with an assessment of damages by setting up a system to do so. There is, I think, an element of subjectivity which judges have, some of you may think wrongly, which comes into the assessment of damages. There's also an element of subjectivity, which I think is necessary in evaluating the evidence of witnesses. Now, whether machines can do that or not, I don't know, because it's something, at least in my experience, that's very human to human type of interaction. So whether a machine could do it, I don't know. But I think that there are certainly some in the Ministry of Justice who think that the problem of backlogs and dealing with lots of small claims is to have a machine to do it, to have AI to do it. Now, looking at just quickly on the criminal side, we've had for a long time systems like OASIS, which are meant to help assess the dangerousness of criminals, the possibility of reoffending, and so on and so forth. It's often used by the probation service. In my experience, when I sat in criminal cases, which I did for quite a long time when I was a judge at first instance, because I was in charge of one of the circuits, the judges themselves, although we'd get the results of the OASIS analysis in such things as probation reports, we didn't use them ourselves directly. I personally felt that sentencing was a very defendant-dependent operation. And I would not be happy with the idea of a machine doing it, and I'm not sure the extent to which a machine can actually do much more than take a series of facts and run it through its algorithm, bearing in mind sentencing guidelines, et cetera, and coming out with a result, which might be used as a starting point by the judge. But I think there's a personal element to it that's going to be essential, and certainly for the foreseeable future will remain essential.
Keeping a human in the loop. Sarah, Sean, Sir Richard said Lord Mustall said that the time will come, and the time does come that you have to address as barristers this machine. How would you feel about it? Do you think it will assist the process? It'd be great to get your views as well.
I think from a public law perspective, it's I can see the benefits in terms of consistency and kind of as potentially as a benchmark. But I think there's always been before we were kind of using this technology a distinction between things that are legally relevant and things that are statistically relevant and have a predictive value. And I would like to think that a lot of the role of the judge is in distinguishing between those two things. And it's very important. You might have something, for example, the fact that a defendant comes from a more deprived postcode, or their racial identity, or the fact that a student whose exam result you're predicting goes to a school that historically hasn't performed well. Those things have predictive value. Certainly they're statistically relevant, but they're not necessarily, and you wouldn't want them to be legally relevant. And a judge is able to kind of make that assessment and draw that distinction where an algorithm isn't, which is not just important because you don't want them to be relevant as a matter of fairness, but also because if you treat them as relevant, then you perpetuate their relevance and bake them in. And so it's not just a matter of fairness, it's also kind of the hope that things might over time become fairer and more equal, and that relevance might be diminished. So I'm a bit sceptical of it replacing or kind of diminishing the role of judges. I might be proven wrong.
I completely agree with you. I think that difference between essentially the role of the law in working out what is morally relevant when we make decisions is so important. And I think this idea of re-entrenchment is definitely a cause for concern in terms of the rules that then get created. But I think also there's a risk of linguistic re-entrenchment as well, because I don't know quite whether sort of the ability of machines to like analyze language is where we would need it to be, and I don't know if it can ever get there. So I remember the last time I was thinking about this, which was years ago, there was a quote in some case about promissory estoppel where I can't remember who described it as something along the lines of like tempering the injustice to the shorn sheep on the side of a hill or something, like the idea being that the contract rules were quite harsh, and then promissory estoppel was meant to make things better. I mean, if you put that in front of a machine that's designed to analyse language, is it going to understand what that means? Is it going to derive the correct rule from the case law? And if you try and make a submission in terms that a machine isn't used to as a barrister, is it going to understand you in the same way that a judge could? Is it going to ask you what you mean in the same way that a judge would, right, and give you another chance to explain yourself? Or is it going to be the case that the machine is going to learn certain buzzwords that it associates with a particular outcome, and then if you manage to sort of learn how to play that particular machine's game at that point in time, are you going to be able to manipulate the outcomes as a barrister through your choice of language in a way that nobody thinks should be the basis on which laws end up getting sort of created, right? So I think if it were to be possible, there would have to be significant improvements in the technology compared to what currently exists, and I don't know if it would ever be good enough. So
I think we should have an AI machine called Denning, and then it would invent all sorts of new doctrines.
Excellent. I'm going to take my chair's privilege to ask one more question, then we'll open up to the floor. So certain areas of the law have developed to remedy quite bad decisions and to deal with maladministration. Shani, you've talked about public law, and those areas of law, for example, the GDPR itself contains provisions for non-monetary redress. And that seems like a good way to maybe think about dealing with some of the harms we've been talking about. To what extent do you consider those frameworks where we're not talking about monetary redress, but rather talking about identifying or stopping other types of harm? Do you see any way that we could develop a framework that provides for non-monetary remedies dealing with a lot of these issues? Maybe Sian first, we'll go down the line.
Yeah, I mean, I've talked about judicial review a bit already, but I think these principles that we've already developed and have already adapted to a huge amount of technological change and huge changes in the way that governments carried out are capable of being applied to automated decision making and the use of these systems by government. It's just not, it's beginning to happen, but we're really only starting to think about it. But I think there are principles that certainly apply. So, for example, you have in public law prohibition on fettering the exercise of discretionary powers. And when you think about that in the context of public bodies using automated systems, there's a strong argument that that requires what in data protection law is referred to as a human in the loop. So it's arguable that that amounts to a prohibition already in public law as it exists today, but applied to ADM, to a requirement to have a human oversight when you're exercising that kind of discretionary power. And similarly, public law already has something we call the duty of inquiry, which requires public bodies to take reasonable steps to understand what it is that they're doing when they're purchasing systems and implementing them. And so that's something that could definitely be developed and used to put more of a burden on public bodies using these systems to show that they've understood it and that they've thought about it and that there's been a kind of sufficiently diligent process behind it. So there are concepts and principles that can be used. They just require these arguments to be made so that they can be developed by the courts. But certainly I think there's a good starting point already there in public law. But
yeah, I completely agree. I also think that public law is the area that has the hooks that are most suitable for AI and sort of machine learning systems. My favourite in the area is the doctrine of irrelevant considerations. So in particular with the way that machine learning operates, one of my favourite examples is quite an old one, but it was about when they were training a machine to recognise huskies from pictures. And they thought it was a really, really good predictor of whether a picture contained a husky or not, until they started showing it just pictures of snow. Because what the machine had started doing was associating a picture of like snow with having a husky in it, because the only dogs that was being shown in snow were huskies, right? So that's an example of a machine essentially learning to take account of irrelevant considerations. And if a public body were to use a machine learning tool to do things like stream visa applications, as happened in the past, or to use in predictive policing contexts, I think there'd be a very strong argument to say that a lot of what was being coded in through the learning process that the machine is adopting would be irrelevant considerations. Now, obviously, there's lots of problems about how you can prove what has been taken into account. There's also a risk of, even if you try and expressly code out consideration of particular irrelevant factors like protected characteristics, then the machine might still be tracking those things by proxy. So how do you identify in what is not only a black box, but once you open up the black box, it's just a mess, right? You can't figure out really what it's doing. So how do you develop tools to interrogate AI to be able to establish these kinds of things? But I think that's probably where I see the strongest hook being. Like, there's some stuff around the Equality Act and competition law as well, but yeah.
So Richard?
Well, I think in many ways public law is the easiest area to deal with, because if AI is making a decision and it seems to be unreasonable, then what's the problem? It's the AI is making the decision on behalf of a public body, we're going to assume. If the decision is unreasonable, then it doesn't matter whether it's been made by AI or whatever. So that's a basic type of case, and there wouldn't be any problem. And you can imagine, for example, in, say, assessments for disability payments, one example, and something's gone wrong with the AI, but it comes up with a ridiculous answer. No, this person shouldn't have any, when it's quite clear, just by looking at the person for 5 seconds, that there should be a payment there. What's going to be more difficult to deal with, and I think this is Sarah's point, when you have irrelevant considerations, is working out whether the AI has considered that at all, and that's the basis on which it's come to the decision on which the public body has acted. And there a problem of investigation and proof is going to be a difficult one and an expensive one. And as I mentioned when I talked earlier, how do we know AI can't cover its tracks? And have we got to develop a system, if we're going to use AI for making these type of public body decisions, to prevent it from doing so? And how can that be done? So I think that it's not altogether simple, but I do believe that public law processes and public law remedies can be used in general easily enough with decisions made by AI.
Thank you. I wish I had more time to ask more questions, but we've got people in the audience that might want to ask questions as well. Start right at the front.
Stimulating speech and commentary. We've not talked much about AI ethics and regulation, but actually I think, particularly with your responses to the last question, I think you all strayed into that area. And of course, what's interesting is China is arguably ahead of the game because they've already established regulations around AI. Coincidentally, by the way, China also has AI judges operating in courts now as well. So we are going to start seeing how that works in practice. But what China has done is has set out a framework for AI regulation around it being ethical and moral. Now, there's some pretty subjective questions around that. But the others are transparent and accountable. And I think that addresses, Sir Richard, your query about whether AI can cover its tracks, because I think if you have some degree of regulation around AI and there is transparency and accountability, then you ought to be able to see what decision has been made. So I just wondered if the panel had views on whether or not actually the solution here is to come up with regulatory frameworks.
I think we'll take a couple of questions at a time, then we can answer them together. Does anyone else have a question? I think this gentleman here.
Thank you. I wanted to ask about granting a legal personhood or legal personality to AI. Does a problem arise in the individuation of artificial people, especially when the same or different machines might share the same algorithms or the same data or even parts of the same hardware? And if these problems do arise, should the solutions to them be guided principally by an understanding of the technology, or should we have a more pragmatic approach, perhaps based on, I don't know, who's best placed to pay the damages or something like that?
Should we deal with those two first, then we'll take some more?
Well, can I say something on the first one? I did notice briefly when doing some research that China has got this regulatory regime. I'm afraid I sort of took out the usual pinch of salt with it, but there's got to be a regulatory regime. As you see, the UK government's approach is a very light touch one, so far as I can see. But I think there's got to be some. There's got to be regulation generally. Two, I'm not sure to what extent the mantra of non-statutory regulation is going to work. The problem with having it in a statutory basis is it then takes an awful long time to change it when the material which you're trying to regulate changes so quickly. I mean, it changes daily, I'm sure. but there should be some principles which are established, which have to be obeyed, and principles such as transparency and accountability must be basic, I think. But as I tried to say earlier, the fact of having regulations doesn't solve all your problems, in my view. How are you going to deal with problems when the regulations are not obeyed and there are consequences for individuals or corporations as a consequence? That's the difficulty. But yes, there've got to be regulations.
Does anyone else want to?
Sure, yeah. So I think a couple of regulations that I'd quite like to see. I think, first of all, if there was some form of mandatory version control type recording, right? So say an AI had to snapshot itself every time that it updated. And I think that would be useful because, as Sir Richard's mentioned, AI, which is sort of self-rewriting, can go back and change, its code, whether it does so on purpose or by accident, doesn't really matter. But for the purposes of legal proceedings, what we want to know is which version of the AI made the decision, right? Because it might be that later on it's not coming up with discriminatory outcomes. And so testing the version potentially 5, 10 years, 20 years down the line when the case gets to court isn't going to be particularly useful in telling us whether the decision that was made on an incorrect basis or not. So I think, first of all, if there were version control requirements that could be, I don't know, in some way analogous to the types of accounting or reporting requirements that companies have, I think that would be a good start. I think the second thing that I've seen spoken about is essentially sandboxing legislation, because there is a problem with asking for access to a proprietary AI in that a lot of companies are unwilling to part with their AI for you to really dig in and interrogate it. And that's been a real problem in a number of US cases in particular, where courts haven't allowed access to the AI because they were more worried about the company's confidentiality concerns. If there were a system where there could be sort of impartial AI experts who could take the relevant version of the AI and sort of interrogate it with their own algorithms or running their own sort of processes to see if, on aggregate, the AI produces discriminatory or incorrect outcomes, that could be a tool that could potentially be quite useful for the courts. So I think those are the two main things that I would suggest in terms of AI ethics and regulation. And then on the question about individuation, I think you're right, that is a massive problem. There's a big discussion to be had about whether different versions of a software are the same fundamental core product or whether it's a different product every time, which is why for a long time the Product Liability Directive completely stayed away from software, right? And I think it is a difficulty not only of assigning sort of legal personality to AIs, as you say, but also in terms of, even if we don't do that, how do we figure out what is the same product and what's a different product? I don't have an answer on that one, just agreement that it's very tricky.
I think the only thing to add to that on regulation is it's all well and good having the regulation, but you have a kind of problem of the volume of information that's being processed, and it's spread quite thinly so that each individual, the impact on them is perhaps tiny, but the cumulative impact is massive. And so you have the same problems here that you have already in areas like data protection law and to some extent product liability, where even though you can have a regulatory regime, but if there's no meaningful way of enforcing it or monitoring compliance, then it doesn't necessarily do a huge amount of good, particularly here where a lot of these, where the decisions are meaningful to people, it's often things like